Hey there, welcome to Help Solve the Case. I'm Christine Burke. Today, we're going to talk about the Matthew Nilo case out of Massachusetts. On an April night in 2023, Matthew Nilo walked his dog, took an Uber from his New Jersey condo to a restaurant and bar in Manhattan, and spent hours at a corporate event. 4 FBI special agents followed him there. The agents watched Nilo from a table of their own a few feet away, past the bread, enlisting a waitress at the Oscar Wilde restaurant and bar to hand over glasses Nilo drank from throughout the evening. So, all they needed to do was pull the server aside and say, when you go, they come and they clear the table. Can I get you more? Are you done with that? And they take it, walk over to the FBI table and hand it to the FBI agent. And you should have already identified the waitress. That's good chain of custody. So let's see what happened. When Nilo and the group he was with left after spending about 4 hours at the restaurant, the agent seized a water glass, a fork, and a napkin off the table. All they could have done is say, when you clear the table, bring it over to our table. Why wait? So I guess what they're saying there is like when you watch a house continuously, they're calling it continuous, that they watched the plate, the water glass, the fork, and the napkin, that they continuously monitored those items and had continuous observation of it. It says the agent's actions that night came under scrutiny during an evidentiary hearing, where I want to get the transcript of that, where Nilo is charged with aggravated rape and kidnapping, among other crimes. Using the DNA samples they pulled from the items, they were able to identify him as a suspect. So that is the confirming STR. That is the confirming STR, according to them. So it sounds like Scapiccio, whatever her name is, once you get arrested, typically they get it again to make sure that it's accurate, and he's not given it. The investigation into those assaults came to focus on Nilo through a process known as investigative genetic genealogy. In Nilo's case, investigators uploaded DNA. He grew up in Boston, arrested a month later. He is claiming it was a violation of his constitutional right to privacy. Prosecutors have defended the investigation, claiming that Nilo abandoned the glasses, fork, and napkin at the restaurant, making them fair game for the agents to seize. Judge Deborah Squires-Lee will ultimately be responsible for determining whose view of the evidence is correct. On Monday, she heard from 2 of the 4 special agents who trailed Nilo to the restaurant that night. It was continued to August after 5 hours of testimony. So we don't have our answer yet. We need to put that on our docket. Whatever Squires-Lee decides, her ruling will be critical to the case. Without the DNA, there is almost no evidence linking Nilo to the assault. Her decision is a near certainty to be appealed to the Supreme Judicial Court whenever it is made. We get to talk about the feds. The first witness called Monday morning was Special Agent James Smith, who essentially led the team of agents surveilling Nilo in April 2023. He explained that their objective was to get a sample of Nilo's DNA either from an abandoned sample, such as saliva, or from an object he used. Generally, investigators are able to take DNA that has been abandoned even if they don't have a warrant. When agents arrived at the bar, Smith pulled aside the manager and explained who they were and what they needed from him. That's the manager. That's not the waitress, because we got this argument we heard that they didn't take any names. The manager placed the agents at a table where Smith said he had a direct line of sight on Nilo. That's what he needs. Continuous tracking. Hopefully he didn't go to the potty. Smith also enlisted the help of the waitress by flashing his creds and pointing out Nilo at the table inside the, quote, temptation room. He told her to make sure to grab Nilo's glass from the bottom so as not to interfere with the DNA around the rim where he had been drinking from it. But Smith said, oh, crap. Smith didn't say that. I said that. But Smith said the waitress appeared to collect the wrong glass first. Oh, crud. Quote, freaking out. I remember it being of a different enough variety that it jumped out. Quote, he testified on direct examination from Suffolk prosecutor Lynn Feigenbaum. Could he have carried a different type of drink glass from the bar? Sometimes, they have a happy hour before you're allowed to go into the meal. If you've been to some of these things, you have to wait out in the anteroom and they have a bar and you get a drink while you're waiting and then you get let into the main room. They're prepping it and all that. So could have been a bar glass versus a whatever glass. When she cleared the table a second time, and this report, I hope it doesn't say this in the report, agents paid closer attention. Oh, God. And realized that she had been collecting the glasses in front of the person next to Nilo. After each, there's an order. If you guys don't know, like everybody has their butter knife and their dessert, like fork and everything. Like there's an order here. She should know whose belongs to whom. There's an order here, especially in New York with a bunch of lawyers. She should have known that. I don't know. We don't know. We don't know. Maybe they were messy eaters. When she cleared the table a second time, agents paid closer attention and realized she'd been collecting glasses in front of the person next to Nilo. After each time the waitress cleared the table, 2 other agents followed her to another part of the restaurant where they took custody of the glass. Agents then packed the glasses into brown paper bags, which were placed inside a backpack. After the agents left the restaurant, Smith took the evidence to the FBI office in Atlantic City and stored it in the evidence room ahead of eventual transfer to Boston. He admitted he didn't know how it would have been transferred. Drive it down. With the first and second glasses apparently collected from the wrong person, agents, quote, redirected the waitress to Nilo. On the third try, she turned over the correct glass, according to Smith. Quote, I observed Mr. Nilo drinking from the glasses that were subsequently collected, he said. On cross-examination from defense lawyer Rosemary Scapicchio, Smith said he couldn't remember exactly what the glass looked like. Y'all, why don't you have an undercover camera on, which would document the chain of custody? Y'all have those pen things and lapel things and glasses and all that stuff. Why wouldn't you put that on to document the thing? Come on. Was it a tall glass, a short glass, a glass for like a food drink? What was it? She pressed. Smith said he couldn't remember, that he didn't see the glass before testifying on Monday. My cops, please refresh yourself by reviewing your body cam and reviewing your reports and looking at the freaking evidence before you testify. Please, you get paid for it. During her questioning, that's how I get them. Defense says, don't worry about it. It's all in your head. Don't worry about it. Sergeant Burke over here says, please do it. We're got to do both things here. During her questioning, Scapicchio seized on several pieces of information absent from Smith's report of the surveillance, including the detail about the waitress twice collecting the wrong glass. Exculpatory information. She pointed out repeatedly that agents never got the names of either a manager or the waitress working that night. Oh my God. I'm sorry. For his part, Smith said that he felt the information simply wasn't relevant. What if you got hit by a bus? Every witness gets a witness statement. Why was there not a written witness statement form? Why would you not put the person's name in the chain of custody log, sign a receipt for some sort of something in the report to put the freaking lady's name down at the time? Because something could have happened to the agent or whatever, and then it becomes hearsay. Don't y'all write reports? Goodness gracious. Please, Cash, whoever, fix this crap. It wasn't relevant. Scapicchio pressed on, pointing out that investigators never photographed the oh, Jesus Christ. I'm sorry. Investigators never photographed the specific evidence seized after Nilo and his group left the restaurant, which included a fork, water glass, and napkin. Did you include everything that you saw that night in your report? She said. Smith said he didn't. What the fudge, people? Feigenbaum next called Special Agent Megan Calpin to the stand. Calpin was one of the two agents responsible, and I don't want to hear it. I know where you're going with this. I don't want to hear it. You got one right in front of you. I don't want to hear it. Calpin was one of two agents responsible for collecting the glasses from the waitress once she had cleared Nilo's table. For the most part, she said, she couldn't actually see Nilo using the glasses she later collected, but she recalled one instance in which the waitress seized a glass Calpin saw Nilo use. So, when you don't know who the hell the witness is, excuse my French, so that they can do a Daubert hearing or some sort of something and testify, and you don't know who that waitress is and you didn't see it, you have a problem. You have a boo-boo. So hopefully the other dude, you're sitting there eating for God knows how long, hopefully the other agent, dude or dudette, saw it. Because you've lost it. Because it doesn't sound, was Smith there? Was the other person Smith? I'm not sure. Let's keep going. Agents were able to discern whether to follow the waitress based on nonverbal signals, she explained. Why do you need a nonverbal signal if you're watching the entire time? We're over here on the defense side, sorry. We would get an indication either by just eye contact or if somebody observed her indicating that this was one to pick up, she said. My thought was if we got up and followed and it wasn't, and we made a mistake, she would have just told us. Why couldn't she put it on that tray and come over to your table and say, can I get you anything? Can I help with anything? And put it down on the table. It's not that hard. With Calpin on the stand, Feigenbaum introduced several photos of the bagged items into evidence, but she did not show either agent the actual glasses, fork, or napkin seized from the restaurant. Hopefully, the evidence tech took pictures. Calpin said she had no role in what happened to the evidence once it had been bagged, collected, and marked. This is so good, y'all. See, you don't need Netflix, right? We got it right here. On cross-examination, Scapicchio raised many of the same questions, asking Calpin about the specific glass she saw Nilo using and how investigators communicated with the witness. Sorry, I read ahead. This is so bad. Quote, I don't know if I had a clear view of exactly what everybody at that table was drinking, end quote, Calpin said, explaining that she was seated with her back to Nilo's table. How many agents did you have there? Why is Calpin testifying? Where's the person that saw the stuff? But she later testified that she repositioned herself throughout the evening so that there were some moments where she could get a view of what the people at the table were eating and drinking. What about just being the freaking waitress or the waiter? Then you'd have had it. You'd have watched it, and you'd have had it. He'd have handed it to you off the table. What about that? Have you not heard of undercover? Not just eating and sitting? Come on. Come on. When Scapicchio suggested the agents were following a different procedure from collecting evidence that they would at a crime scene, you betcha, Calpin replied, we were just collecting abandoned evidence. That's the same as the crime scene? Like trash on the ground and cigarette butts and stuff, right? Like, right? Chain of custody is the same, right? Y'all know that, right? It's not just me thinking that, right? Following the hearings, Scapicchio distinguished Nilo's case from others solved with abandoned DNA, arguing that Nilo was reasonable to expect privacy inside the restaurant. No. The way they stole his DNA here is different than leaving it at a crime scene. This wasn't trash. That's a good argument because where do your plates and drinks go? Don't they get scraped in the trash? What do you think about that? I can't believe this SJC, I don't know what that is, Supreme, I don't know what that is, a judge, I don't know what the SJC is going to say without a warrant, they can go in anywhere they want. She added, suggesting that the seizure Nilo was subject to comply to a myriad of other situations if allowed to stand. What do you think about that? What do you think that he thought in reality? What do you think that he thought they were going to do with his plates and his napkin and stuff? What do you think? Do you think that was individual to him and they were going to keep it? What do you think? Let's see what else we got here. Key hearing. Did we read this? Here, we didn't read this one. A hearing on Monday. So we're waiting the results. Judge Deborah Squires Lee. So they did that. We don't have that yet. I'm trying to get that. In Nilo's case, investigators used DNA recovered from a sexual assault evidence collection kit performed on one of the victims of the Charlestown attacks. Using that DNA, federal investigators found relatives of Nilo who consented to reference testing. Gosh dang. Y'all, quit this crap with the reference testing. God dang, do the freaking genetic genealogy the right way. I gotta stop. My cops, no reference testing. You don't need reference testing when you work your leads properly. You don't go out and shoot the Q-tips around the country hoping to get lucky. A professional, experienced genetic genealogist will know how to work the leads and get the identification properly. No reference testing, period. That information led investigators to construct a family tree, which eventually, that the reference testing is, we need a bigger match. And you guys know, in my intro video, if you haven't watched it, that is a disgusting, non-investigative way to get lucky on a case. You don't need a bigger match. You work the leads that you have, especially if you're in MyHeritage and you cannot figure out who the frick it is, then you have a problem and you need to call me. But this reference testing and this waiting for a bigger match is no. Sorry, I told you guys I was very upset and disturbed about this stuff. Disgusting behavior. That information led investigators to construct a family tree, which eventually led to the identification. Look, if you were in MyHeritage, you'd have had it. You should have had it. I don't know what's going on here. Y'all need to call me. No group solves, no nothing. Y'all need to call me. But anyway, investigate like a cop investigates. Don't be spraying and praying with the Q-tips. That information led investigators to construct a family tree, which eventually led to the identification of. After homing in on Nilo in April 2023, FBI agents trailed him to a work event. Why didn't they just get up his trash? There they see 6 items that agents saw Nilo use, including several glasses and a utensil. The DNA recovered from those items matched the DNA evidence collected from the Charlestown rapes. He was arrested a month later. After arrest, they identified him as a suspect in a series of rapes and assaults in Boston's North End. If he was in CODIS, why did all those arrests have to come later? Were they not entered? Was it a backlog? He faces charges including rape, aggravated rape, causing serious bodily injury, kidnapping. Scapiccio, in moving to suppress the DNA evidence, claimed the search and seizure violated Nilo's privacy rights. Society would recognize this expectation of privacy as reasonable, where society would not believe the police are entitled to follow a person into a private establishment and seize their silverware, dining plates, glass, and napkin in order to secure bodily fluids to obtain DNA, her motion reads. Why not get the trash? Like I said, they could have just touched him. They could have rubbed up against him in the Uber or whatever. I don't know why they did that. I don't know. They could go in the courtroom where he's prosecuting cases or whatever. Come on, there's plenty of opportunity. I don't know, whatever, feds, I don't know. But Suffolk County prosecutors argued that because Nilo voluntarily discarded the items, investigators could seize and examine them without violating the Fourth Amendment. In their opposition, prosecutors refute the idea that the use of Nilo's DNA after it was seized was an independent search or seizure in and of itself. And they wrote, Nilo had no privacy rights associated with the search of the genealogy database because any rights to privacy would apply to the people who uploaded their DNA. So we got to talk about this. What do you think about the items being discarded? You go eat at a restaurant. Do you think that the people there with hundreds of people, I don't know how many people were attended, they're going to take it one by one to the washing thing and hand wash every item to make sure that your DNA is off of it? I just don't think that's reasonable. I don't agree with that. Now, the second part, the genealogy database. Somebody was talking about carpenter, which carpenter I don't believe applies. It applies to flock, but not to this, because it's a neighborhood canvas. It's a neighborhood canvas in that. Now, the MyHeritage issue, I'm not formulated on that yet, but I will talk about GEDmatch and FTDNA where people opt into law enforcement matching. And it's like the neighborhood canvas where you get a description of somebody like Crime Stoppers and the picture goes out or the whatever goes out, the information goes out and you go, that sounds like my cousin Jimmy in the Tyler Robinson case. Parents said, that sounds like the gun. That could be my child. And they turned him in. They made a tip, right? They called someone, they turned him in. This is not the first time that relatives or friends, girlfriends and boyfriends have turned people in because they recognize the manifesto or the whatever that lends itself to be that person. And as long as that is credible, how is that a problem? Let me give you better. So I know what you're going to say. You're going to say Matthew Nilo wasn't in the database and he didn't ask all those relatives not to dime him out, so to speak. And again, he doesn't have to be in there. The technology is so good. I can trace it back to ancestral Adam and ancestral Eve, very small centimorgans. Those are all my DNA in there. Those are all my relatives. They are not random people. They are all my relatives. They all belong to me, nobody else. So let's just take a totally different situation here, right? And we'll argue it. Let's talk about it. If my picture is posted on Crime Stoppers and my sixth cousin twice removed says, that looks like my cousin Christine, it doesn't matter if I've never spoken to her or I have a beef with her or I never told her not to dime me out to the cops or whatever. She recognized it and provided a name. Ergo, the database is the same way. That sixth cousin recognized the DNA, the database recognized the DNA was recognized, the relatedness was recognized, the familiarity was recognized, and it spit out a name. It didn't spit out a name. They had to build down to the name. Just like someone could say, you know what, that really looks like someone in my family. Like when I started looking at my family and I'm looking in the database and I'm like, not my people are my people. And I couldn't tell. It was just from me looking. But that's what this is. Happens all the time. Neighborhood canvas, people talking about other people and giving leads. Just if you ran past someone's house down the street and they came out and they said, I think that was Johnny. It's voluntary. They are voluntarily in the law enforcement database portion, voluntarily talking to the police. Their DNA is voluntarily talking to the police. It doesn't need his DNA to dime him out, right? It's not a one-on-one CODIS hit. It's the relatives. So if they legally have his DNA from the crime scene, like a surveillance photo, and the family members are saying, that's Johnny, that's that. This is something we want to talk about. Let me know what you think. All right. I'm happy to try to articulate it better. So, prosecutors said Nilo had no privacy rights associated with the search of the genealogy database because any right to privacy would apply to the people who uploaded their DNA. Yes. Like like I said, if I'm living in my house and I'm looking out my window, even if I'm unrelated to Johnny, and I see my neighbor Johnny running by with a knife in his hand, and I say, oh my God, my neighbor Johnny was running by with a knife in his hand. Does the defendant have the right to expect privacy that I'm not going to dime him out? No, he doesn't, because I recognize him as my neighbor and I saw him with a knife in his hand. He doesn't. Argue it. Let's go. It's the same application. This DNA, they think, while it is a novel technology, law enforcement is still law enforcement. This is why this has to be a law enforcement function. It needs to be operated like a law enforcement function. There is no difference. There shouldn't be this chain of custody crap with taking in the evidence and all that. It's not any different. They should be operating under standard police procedure. And this is no different than a neighborhood canvas and somebody diming somebody out. No different, in my opinion. Tell me contrary, tell me something else, and let's talk about it. Prosecutors say he knowingly waived his Miranda. Scapiccio has also moved to suppress Nilo's statements to police after he was arrested, but prosecutors say he knowingly waived his Miranda rights and point to the fact that his interview ended once he asked for a lawyer. Without DNA, the defense has moved to suppress. Prosecutors have no case, Scapiccio says. So she says that. If we win the motion to suppress, then there is no evidence, she told Mass Live following the most recent hearing, noting that no witnesses identified Nilo as a suspect and police never put him in a lineup or photo array. They could do that now. Hopefully they didn't show him a one-off, but Nilo is one of several long cases. I want to look at those cases. She drew a distinct line between the actions undertaken by investigators in Nilo's case and other similar cases, noting that Nilo's DNA was seized after he attended a private event. We keep hearing that word private at a restaurant. But in the defense's view, Nilo didn't abandon the glass or dinnerware because he had no opportunity to take him with him out of the restaurant that night. I don't understand that argument. She's doing a good try, but I don't understand how you would think that you're going to go to a formal event. Have you ever been to a formal event like a wedding where there's china and silverware and you think that that stays yours? Here's an example. Some of the bars, sometimes you can buy your mug or rent your mug and it hangs up. And then when you come in the bar, they take your mug down for beer. That's a little different. This is my plate and this is my glass and this is my silverware and nobody is to use it like a reserved table. Nobody is to use it until I come. It wasn't that. I don't understand. I understand what she's trying. She's trying, but I don't understand that. What are your thoughts on that? She says the public should be terrified. Let me tell you, you leave your DNA everywhere all the time. That's what I'm saying. They had so many different opportunities to get it here. So let me know what you think. Very interesting. We will keep tabs on that. If you find the pleadings, please let me know because I want to hear I really want to see those police reports. And we'll keep talking about this. So one of the other issues with this was some expert was saying that search warrants need to apply and that carpenter applies. And I disagree. And I don't want a search warrant necessitated for this because as I'm explaining, it's very hot here, you guys. The neighborhood canvas does not require a search warrant. So you don't need a search warrant. The people have opted in. Now that MyHeritage thing, no cheating. No cheating. No cheating. I don't know, the permission, whatever the shit is going on with that needs to stop. I don't know. You do things the right way. You work your genetic genealogy the right way. You don't need to be cheating. And if you can't work it, like some cases seem to be, you can send it to me. What else was I going to say? We're going to continue watching the cases. And I will see you on the next one. I got a lot to say, but I'm going to look at those other cases. I will come back because I know this has been a very long video. And we'll keep talking about it. And I made a post in the community on the YouTube channel, which is different than our community in the helpsolvethecase.com app. And you can ask your questions there so I can answer them regarding DNA. If you have questions about this for DNA or whatever, put your questions here and I will do my best to answer them. My goal is to have just a specific DNA question that may cover a DNA session or video that will cover all the multitude of cases. Once again, thank you for being here. I appreciate you liking, subscribing, and sharing, because part of what you do here helps me donate my services to work on these rape cases, these unknown human remains cases, and these unsolved violent crimes. So thank you. I really appreciate it. Can't do it without you.